In this section of the training, we're going to look at the mock trial and the trial itself. So as you begin the trial, the presiding judge will lead any pretrial or preliminary matters. What you might see as the judges and students may quickly introduce themselves. One thing you don't have to worry about is any kind of Zoom recording of the trial, as currently our competition committee has ruled that no Zoom recording of the trial is permitted. So you don't have to worry about that. During this pretrial, you might want to check for questions related to judicial preferences. Some students might ask how they'd like to see, the judges would like to see them responding to objections, for example. You might also see the students ask for recognition of the stipulations in the case, and so it might be common to see that those talked about and worked through. Under our mock trial rules, there's no separation of witnesses. Everybody's going to be in the room together. And you might have any other issues or ask if the students have any other issues that they wanted presented at the presiding judge's discretion. At this pretrial meeting, do not expect the students to provide any kind of trial material, and they should not be doing that. So you should not expect trial binders, exhibit papers, statements, anything like that. Judges, you should have the witness statements and exhibits and the whole case file open and available to you, whether that's still digitally or printed out and have it ready on paper. Don't expect any kind of oral summary given by the team prior to the trial. That's all coming through during the trial itself. And don't anticipate and do not entertain any motions or seeking judicial notice of any items. So you're going to have things like, again, no separation of witnesses, no voir dire of the witnesses, and things like that. For mock trial purposes, all witnesses are assumed to be sworn in, but it is still nice to have the presiding judge ask all the witnesses that are going to testify to come onto video and go through a swearing in prior to the trial or prior to any witness testimony. And you can see something using something to the effect of, do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of mock trial competition? The trial sequence is following the standard sequence for trials. So you will have an opening statement, the plaintiff followed by the defense. The plaintiff will give their case in chief, followed by the defense, and then the closing arguments, again, plaintiff followed by the defense. For the opening statement, again, each side will give their opening statement. Each side has 5 minutes for this opening, and you will not entertain any objections during the opening statement. For the cases in chief and the witness testimony, again, the plaintiff will present first and then the defense. Each side has 3 witnesses, and all 3 witnesses will need to be called. You'll go through the direct examination of the witness and then the cross-examination, and then the teams have the option to add a redirect or a recross. The scope of the cross is not limited to the direct. Both the direct and the cross have open availability to the witness statement. The redirect, however, the scope of that is limited to what was talked about on cross, and the scope of recross is limited to the scope of what was talked about on redirect. When you look through the witnesses and when you hear witness testimony, the witness statements can be used by counsel to impeach a witness or to refresh a witness's memory. The witnesses may not bring their witness statement or notes to be used as a trial aid while they're giving testimony on the witness stand. If a judge thinks this is happening, the judges should bring this to the attention of the court and make sure that the students are not using any witness statements or notes during the trial. Witnesses must conform their answers to their witness statement. And so if a witness invents an answer that is likely to invents an answer outside their witness statement, that it affects the outcome of the trial, you might find the opposition objecting. And so teams that are intentionally and frequently stray outside the case materials should be penalized with a lower score. If the attorney who is cross-examining a witness asks a question that is not actually explicitly answered in the witness test statement, the witness is free to create an answer as long as it is responsive to the question, doesn't contain an unnecessary elaboration beyond the scope of the witness statement, and does not contradict the witness statement. You'll find that students may object during the trial, and those objections may be based on the rules of evidence, as well as for violation of the rules of the competition. Again, no objections can be raised during opening or closing. When an objection is made, the presiding judge will be the one to rule on the objection. You might give each attorney the chance to state their position, and you might give that objecting attorney a chance to respond, but we do ask you to keep the trial moving and not go back and forth over and over again. Once you hear each attorney argument, make your ruling. Here's what we will say. Your ruling doesn't have to be technically correct, but you should follow as much as you can the rules of the competition, rules of evidence, and what a judge might do. Your scoring and your evaluation is going to be based on the fact that they're making proper objections and the proper arguments, and not whether you sustain or overrule the objection. So think about that it might be important to let testimony come in without completely derailing a team's strategies, because they might not be able to recover. With that said, it is a skill that you can evaluate to be able to improvise, adapt, and overcome when an objection ruling doesn't go your way. The only exhibits that students are able to use are the ones provided in the case material. With the trial being on Zoom, you might find students that might choose to use the screen share opportunity to show the exhibits that they are discussing to both the opposing counsel and the witness on the stand. Regardless, all participating students have been informed that they should have their exhibits handy, again, whether digitally or on print, if they are referencing them. Judges, you should also have that case handy, again, either digitally or printed out, and so able to be referenced if they're talking about exhibits. In the case file, those begin on page 47. Once the defense rests, you can take a short 2 or 3 minute break to be able to have the students be able to refresh and start planning their closing. Closing arguments are only 5 minutes long for each side. The plaintiff will deliver their closing first, followed by the defense. The plaintiff has the option to give a rebuttal after the defense closing argument. They are only able to use the balance of their 5 minutes, not originally used. And again, no objections are allowed during the closing argument. Once everything is completed, each judge may offer a minute or two of constructive and positive comments regarding the team efforts. Please do not announce the winning team. This is just your chance to give some feedback, not announce the winning team. Once the trial is ended and all the comments have been given, all the participants are free to leave the trial and leave the Zoom link.